The criminal justice system has three core components that are the foundation to it functioning properly. The first core component and the first step to the criminal justice system is law enforcement. Law enforcement's primary role is to enforce the laws that we have established as a society, to ensure that the communities are safe and that the public is protected. The second component of the criminal justice system are the courts. The primary purpose and the most important function of the courts is to uphold the law. The final core component are the correctional institutions. Correctional institutions can include jails or prisons on the federal and state level, and probation or parole departments. Problems that keep the system from functioning effectively and efficiently. One of the biggest issues for the efficiency of the criminal justice system is the due process and rights of individuals. Our system's foundation is based on due process, but it can slow down everything from police investigations to the court system. A second issue within the criminal justice system is the sheer size of the system. Law enforcement, the courts, and correctional system all work independent of each other, but must also work together. Without the cooperation from all components, the criminal justice system would turn very slowly or grind to a complete halt. The UCR was developed as a way to track and analyze criminal statistics in the United States. Statistics are collected on 8 criminal acts that are considered the most violent. Those crimes are murder, sexual violence, robbery, arson, motor vehicle thefts, larceny, other than motor vehicle thefts, burglaries, and aggravated battery and assault. All are listed as Part 1 offenses. Part 2 offenses are also part of the UCR, but are considered the less serious crimes. The UCR reflects the number of crimes committed and the rate they are cleared. The true form of the American criminal justice system really began with the U.S. Constitution. Those rights and freedoms that were given almost 250 years ago still hold true today. The same dual court system exists today. The federal consists of the Supreme Court, the Courts of Appeals, and the Courts of Military Appeals. The state courts include the state Supreme Courts, the district and local courts, and the appellate courts. Other similar comparisons can be found in the courtroom. The principal players have remained the same throughout history. Those include the judge, the prosecutor, and the defense attorney. One component that has evolved over time is law enforcement. Early law enforcement practices were heavily influenced by the British, but as communities changed, so did policing in the United States. For example, with the age of terrorism, law enforcement on the federal, state, and local level have had to adapt to this new crime era. With cyber and religious terrorism on the rise, the courts have also had to adapt to our changing world. Another aspect that has evolved is crime itself. As the world and technology has changed, so has the meaning of criminal acts. With crime changing so much, law enforcement and the courts. In 1822, the Peelian Principle was established in Britain by Robert Peel. These 9 principles were a blueprint of professional policing in the Metropolitan Police. I believe that each one of these principles can be related for society today and law enforcement officers that serve. Robert Peel's principles revolve around the concept of community service, community safety, service of the people, pride, and professionalism. Communities and local police departments can come together to form a partnership that isolates problems and works together finding solutions. The individuals who have been accused of a crime is classified as a defendant. The defendant's first step in the criminal justice system is an arrest. Once they are arrested, the defendant is taken to the local jail until they are brought before a judge or magistrate. The first appearance is the first court appearance before the judge. During the first appearance, the judge will inform the defendant of the charges, determine if there is probable cause, appoint an attorney for for indigent individuals and determine a bail amount and conditions. The next court hearing will be the arraignment. The defendant during the arraignment will plead not guilty, no arrest, or guilty. If the defendant pleads not guilty, then the court will be given, and so starts the process toward trial. If the defendant does not resolve the case between arraignment and the trial, the case will be decided by a jury or the judge. If the defendant is found innocent, the case is done and over. If the defendant is found guilty, then there will be a sentence placed by the judge. The defendant may be sentenced at the conclusion of the trial, or a PSI or pre-sentence investigation may be ordered. If a PSI is ordered, the defendant will be sentenced to at a later court date. The courtroom is the heart of the criminal justice system. The purpose of the courtroom and the criminal trial is to make sure all procedures are properly followed and to determine if the defendant is guilty or innocent. The first stage are the pre-trial matters. This includes any rulings that the judge may have to make or any speedy trial issues that need to be resolved. Another part is jury selection, where the prosecution and the defense attorney will ask potential jurors questions. After asking the questions and both sides agree, an impartial jury will be sworn in to determine the case. The second stage of the trial will start. This begins with opening statements by both the prosecutor and the defense attorney, and the evidence to be presented. The final step in the stage will be closing arguments. Closing arguments are a summation to the jurors that reflect all the evidence that was presented. The final stage are the juror instructions, deliberations, and the verdict.